Good day. This is Daniela Ellerbeck, Legal Advisor to Freedom of Religion South Africa, commonly known as 4SA. Today, I want to give a further update on the hate speech bill after the Department of Justice returned to Parliament on Wednesday, the 21st of September 2022. So, what happened during this latest meeting? Well, as 4SA reported in our previous updates, during the previous meeting between Parliament and the Department of Justice, Parliament highlighted that certain public submissions were not considered by the Department, and it tasked the Department with going back, considering these omitted submissions, and then reverting to Parliament with the Department's responses to these omitted submissions. Now, the Department duly appeared before Parliament on Wednesday, the 21st of September, and at this meeting, the Department gave its input on the issues which were raised in these previously omitted submissions. Now, these included, amongst other things, the concern expressed by numerous organizations and people that the definitions of harm, victim, and hate speech are too wide, that the prohibited grounds are too wide, and that the religious exemption clause is too narrow to offer sufficient protection. It is worth noting that in the working version of the bill, last presented to the committee on 9th September 2022, harm is now defined as any emotional, psychological, physical, social, cultural, or economic harm that severely undermines the human dignity of the targeted individual or groups. These groups include age, birth, color, conscience, culture, HIV or AIDS status, language, marital status, pregnancy, race, religion, sex, sexual orientation, gender, gender identity or gender expression, and sex characteristics, to name but a few. So what were the Department's responses? Well, the Department's Deputy Minister conceded that the bill goes wider than the Constitution, which defines hate speech very narrowly as the advocacy of hatred on the grounds of race, ethnicity, gender, or religion that constitutes the incitement to cause harm. However, the Department is taking the view that a wider definition than the one provided for by the Constitution, even though it criminalizes expression protected by the Constitution, is permitted following the Constitutional Court's judgment and definition of hate speech in the case of John Xolani. Now, this is problematic because, as 4SA has pointed out before, the case of John Xolani was decided under the PEWDA, or the Equality Act. In other words, a civil, not a criminal law, which only imposes civil remedies such as an apology. By contrast, the hate speech bill proposes making hate speech a crime. A major concern is that due to the wide definition of harm, the bill's proposed definition of hate speech is wider than the hate speech definition in the Equality Act. We are still therefore left with the problem of it being easier for you to be found guilty of a crime and sent to jail for hate speech under the bill than to be ordered to apologize and pay a fine under the Equality Act. Similarly, when it comes to the concerns raised regarding the bill's expansion of the Constitution's 4 listed categories to the bill's approximate 23 listed categories, the Department's response was that Xolani allows for this. Again, the Constitutional Court allowed for the broadening of categories in the Equality Act, a civil law, but this does not automatically mean that the same would be constitutional for a criminal law. On the issue of the religious exemption clause, the Deputy Minister stated that the clause would apply to individuals evangelizing on the street. This is contrary to a statement he made in 2018 when he said to the Parliament Committee dealing with this bill that this exception would only apply to sermons and not to statements made by individuals. This alone illustrates a big problem, namely that the clause is not drafted clearly enough and is therefore open to multiple interpretations. On Wednesday, the Deputy Minister also stated that you would be able to claim the exemption if you were interpreting, proselytizing, or espousing, but not if you were, for example, having a conversation in a bar and said something harmful. Again, the wide definition of harm is problematic, as it is the lack of clarity regarding the bona fide religious expression by the so-called exemption clause. Now, the bill is not currently open for public comments. It is being considered by Parliament, and 4SA will continue to monitor the process and keep you up to date as it develops.